Okay, thanks everyone. This is Share What You Know, first episode in the Masterclass series on IP patents and everything related to it. And the whole series is in collaboration with our good friends at Neutromics. So thank you to Rosie and Roy and everyone there to be able who've helping put together this series with some experts in the field and providing really valuable information to THT Plus members and those that want to attend as well, which hopefully in the end will, enable and educate the industry and help just people think about how to go about innovating, building something and getting the right foundations as part of it. So this episode, this first presentation, this session is one of five? Yes, five. That we'll be doing. And Rosie's going to be taking us through, and there'll be slides that she'll be sharing. We'll have a few people join live in this, but many also will check out the recording in the Talking Health Tech community or on our website as well. So if you have any questions live, just Rosie mentioned as well, just jump in and ask. We're doing it as a Zoom meeting, so anyone can jump on. Feel free to, if you're just attending and watching, feel free to leave your cameras on or turn them off if you feel more comfortable with that. It's totally up to you. But it's supposed to be collaborative and kind of an opportunity for everyone to share their experiences and put it in context rather than be like a webinar or a big presentation where you just put stuff in chat. So just open up your mic if you want to chat. That's it. If you're not talking, just go on mute. And that's that. So Rosie, I might hand it over to you to get things going and share your screen.
Thanks, Peter. Okay, let's see if Okay, can you all see my slides? Great, and I can't see anybody, so just jump in with any questions. And given the amount of content, I might go a bit quickly because the better stuff's probably towards the end. But so this is session's just about an introduction to IP. Doesn't want to go down. There it goes. So what I'm going to cover today is types of intellectual property, what is a patent, inventorship versus ownership, obtaining a patent for an invention, starting the patent process, patents, it's all about the claims, and an overview of the patent process. I will preface the whole discussion about patents. It's not Australian-centric, but because patent laws in all the different countries and regions are similar but not the same, I've tried to cover as much as I can just to give you a good feel and flavour of an introduction into IP. So we've got here the types of intellectual property. So we have patents, and these are what protects inventions. Some examples of pharmaceutical drugs, Bluetooth. They have a limited period of time, so it's 20 years from the filing date of a standard patent application. And just later on, I will clarify the difference between a provisional patent application and a standard patent application. And although they're valid for a period of 20 years, most countries, you need to pay renewal fees or periodic maintenance fees to keep them alive. If they're not paid, it does lapse. And certain jurisdictions, you can extend the patent term. And in the US, they have a patent term adjustment for delay. So they do this calculation and add some time at the end. So it can be slightly over 20 years. Then we have trade secrets. So these are things that protect your knowledge and know-how. One of the famous ones that we might know about is Coca-Cola's recipe. They didn't bother to patent that. I'm not sure if it was patentable because no one knows what it is. But you usually keep a trade secret because you want to keep it for as long as possible, so beyond the 20 years versus a patent. But of course, it only remains a trade secret provided the information remains confidential and functions as a trade secret. Then another type of intellectual property is designs. In the US, they're called design patents, but other countries just call them designs. These protect the visual design of a product, so it's ornamental, not functional. I've just got a little example there you might be able to see, which is the design of the Crocs shoe. This is also a limited period monopoly, 5 years from the filing date with renewable for a further 5 years. That's probably more Australian-centric. Other countries would have different terms. Then we have trademarks, and these have been broadened out over the years. So it protects words, symbols, logos, shapes, sounds, or smells, slogans, there's other things, and then in relation to goods and services. So I've put our trademark there, Nutrix. We've got the little apple symbol and the sound of the Harley and fragrances. And trademarks are protectable for periods of time. So you get your initial 10 years, and then you can further renew them for 10-year periods. And you must, I've put there in brackets, continuous use in respect to the goods and services. So if you stop using your trademark for a period of time, depending on the legislation, it can get knocked out and invalidated for non-use. And then we have copyrights. This protects original creative works in tangible forms, so things like books, movies, photographs, pictures. And it's a very long time, so it's life of the author plus 70 years.
Do you have to register all of those? Like a trade secret is just something that exists because it's a company and it's a secret? Is that what it is?
So that's a good question. So with patents, you need to apply for it. Designs and trademarks, copyright is automatic. And trade secret, obviously, as you said, no, provided you keep it secret.
So you could just put a copyright symbol at the end of something and say it's copyright. And then
yeah, as soon as you create it, it's there. And we all create, I think we all create copyright, whether it's worth anything. Drawings is another story, but yeah. So that's automatic. And you can actually register copyright, but you don't have to. But the registration, I think puts it out there that you're the owner and sort of gives it the date when it started. So some countries do allow you to register, but it's not mandatory. Okay. So what is a patent? It's an intangible asset, but it is a form of property. So it does have value. Obviously, value depends on what the invention is and what it's worth. It can be sold and rented or licensed, as the term would properly be. What does it give you? It gives you the right not to use your invention, but the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention. And that's very important because some people think that when you get a patent, you have the right to use it, but you don't. You might get a patent and you go to use it and you find that you're actually infringing on someone else's rights because they have something similar to yours. But a patent is a legally enforceable right, so you can take it to the court and, if you need to exert it against someone else. As I mentioned before, it does have a limited monopoly term. It's typically 20 years. And the whole patent system is based on, I'll give you this monopoly term, and in return for that, you'll disclose your invention to the public. Publication takes place 18 months from the earliest priority date. I will explain priority date a bit later on. And this, I found it fascinating when I was learning patents, that this sort of system arrived from, an apprentice having to take, at the time it was 2 7-year terms to learn the craft from their craftsman. And so that's how it all derived back in the day, a long time ago. But now they've increased. It used to be 14 years, now it went up to 20 years at some point. Patent rights are territorial, so protection is only in the country or region in which the patent is granted. So if you have an Australian patent, it won't stop anyone anywhere else in the world from using it and doing anything. Of course, if they're trying to import into Australia, that's different, but these are territorial. And this is where the costs come in, because you have to decide where you want to seek protection and pay for it in every different jurisdiction. And we will at a later session talk about patent strategy. And I have put at the bottom there, no worldwide patent, because people think there is a worldwide patent, but there isn't. You must apply for and be granted a patent in each country or region of interest. I will mention there is an international patent application, but I'll mention that a bit later on and explain that. But it doesn't give you worldwide patent rights. Is there any questions there? Okay, moving along. So inventorship versus ownership. So an inventor, that's a natural person. I'll put an asterisk there and I'll explain that in a minute, but it's a natural person who contributed to the conception of the invention that is the subject of a patent. So the contribution can be large or it can be relatively small, but it doesn't include someone who merely identified the problem that you've solved or followed instructions to reduce the invention to practice. So if you're in the lab, you came up with the idea and worked out, how you're going to solve this problem, and then you gave it to your junior to do some experiments, that junior won't have any inventive contribution to the invention. Now, the asterisk there is because of relatively recently, Australia, the Federal Court of Australia decided that AI systems can be named as an inventor. It's a very controversial decision, and because of that, the Commissioner of Patents has appealed the decision. So we're going to watch this space. In the US, they have decided that AI systems cannot be named as inventors, but it's quite clear in their legislation that it is a natural person, whereas ours legislation here in this country, I possibly assumed that they didn't have to specify that, but because of that, the courts found that they can. I think the decision will be overturned, but we'll have to wait and see. And of course, with inventors, you could have more than one person named as an inventor. So you could have joint inventorship, people contributing different parts of the invention. And then this is compared with ownership of a patent. So the ownership of the owner of an invention always starts with the inventor because they're the ones that created it. But the inventor may not have the right to apply for the patent. So the right to apply for a patent lies with the applicant. There is different terms given to that entity, applicant, assignee, in different jurisdictions. And this is the person or entity that legally obtained the rights to the invention. So they might have done that by employment, a contract, or some other means. And it is under our legislation, at least, that if you're been doing your normal course of your duties as an employee for a company, unless your agreement stipulates otherwise, your employer will be the owner. I'll just take a break after each slide. If you want to jump in with questions, otherwise I'll keep moving along.
My question's probably going to come up later on in terms of when you would use those and why and all that kind of stuff. You're mentioning about strategy and bits and pieces, so I might wait for the end.
Yeah. Okay, that's good. And probably I've sort of left more of that strategy and decision-making things to the company to a later session, but I'm happy to take the question and to have a chat if we've got time at the end.
Yes.
Okay, so this slide's about obtaining a patent for an invention. Now, this is not Australian-centric, but very flavoured for Australia because that's what I am, an Australian attorney. So for a patent to be granted, an invention must be a manner of manufacture. So it has to be some tangible invention, so patentable subject matter. It can't be something like a perpetual motion machine. It's got to have substance to it. Another term you've probably heard in relation to patents, it must be novel. So the other term for this is it has to be new. So before you applied for it, it couldn't be out there in the public domain anywhere in the world by you or another party. I've just put in brackets there that some territories like Australia and the US, and there's others, have a 12-month grace period. So you can put it into the public domain and then go, oh, no, and then file a patent with it within the 12 months. But of course, that's territorial again. And then another one here is involve an inventive step. This is another term that we use instead of obviousness. So it just can't be obvious. And obvious is tested by someone who's got the knowledge and experience in the technological field. And if they knew, with their knowledge and with all the publications out there, could they have come up with your invention? And that's a lot of the objections that are raised. Examiners put this knowledge and publications together and says, your invention's obvious and you have to argue it. And of course, it must be useful, have utility. And not being secretly used by you or with your consent. And I think I've got it in a further session where we compare patents to trade secrets and why we would choose one over the other. And, what are the pros and cons of doing that? A valid patent, so you could get a patent granted. It does go before the Patent Office and goes through its rigor of examination. But for it to be valid, it must meet other requirements. And these do differ from country to country, but generally it must be your patent specification that you filed in support of your application. It must be sufficiently clear or enabled. So what you're disclosing in your patent specification must provide all the necessary information about the technical details of your invention so that others can perform the invention once it's no longer in force. And that comes back to that exchange of, I'll give you this monopoly term so that you can do this public disclosure, and then once your patent's expired, everyone else can then use it. And your patent specification, it must provide sufficient support for the claimed invention. So you've got to have this best method of performing the invention, include examples. It's not a mandatory thing, but it's very helpful to have examples that exemplify your invention. So for a pharmaceutical, a new molecule that's going to be a pharmaceutical drug, you would have test results showing how it's got activity and things like that. And then your claims must define one invention only. So your patent can only be granted for one invention. If you just happen to have two inventions defined, and there is criteria of what is considered to one invention compared to the other invention, if there's no link between them, they're considered to lack unity. You do have the option to then file what we call a divisional application. So in a patent, you can have an apparatus and a method for using apparatus because it would have the same inventive concept, but you could have two different types of apparatus, one doing one thing and one doing something else, and they don't share any inventive concept together. Okay, so starting the patent process. So it all starts with an idea, but of course, you try and keep it secret so you can seek patent protection. Otherwise, you could lose the chance to get patent rights there. A lot of people talk about conducting patent searches, and these are done to allow you to make an informed decision. And there are different types. And I believe that we may have a session coming up at some point in the future that will go into a deep dive into patent searching and other types of searching. But I've just put here the main types of patent searching that get conducted by people wanting to look at patents. So you've got patentability or prior art search, and this is to assess whether you can protect your invention with a patent. It's not mandatory to do a search, but it's a good idea. It'll show you what's out there, what you might need to work on, and give you an indication of whether you're going to get your patent through. And then we've got this landscape search, and this provides you with a snapshot of the patent situation of a specific technology. Oh, I've done a mistake there. Sorry about that. So these are conducted to see what is everyone else out there doing, where there might be gaps in the technology that you could work on and therefore be able to seek patent protection. And then we have freedom to operate search. And this is a lot with startups that get asked, have you done a freedom to operate? And this is, to determine whether you can practice your invention without infringing someone else's patent rights. Usually you would do a freedom to operate search once you know what your invention is and what's going to actually be on the market. So once you've got all your features down pat or very close there too. And then I've got here drafting the patent specification. Now these are normally prepared by a patent attorney, but there are people out there who will self-prepare them. And I did see on IP Australia's website they listed some of the common things that go wrong when you self-prepare. As you can see from these slides, there's lots to know. It is cheaper to do it yourself, but, engaging a good attorney and getting that relationship going and getting their assistance, it can be worthwhile. So patent specification, this consists of a title, a background, a description, including examples and drawings or figures, as you want to name them, and the claims. And there's independent and dependent claims, which I'll discuss later on. And then there's the abstract. That's not part of the patent specification. That's separate to the patent specification. And that's an initial little abstract that might get published at some point in a shortened form, but not the publication in 18 months. What gets published at 18 months is that whole specification. So what type of patent application to file? So people that are somewhat familiar with patents will probably have heard about the provisional application. This is typically what most people choose to file in the first instance. And the reason can be a low-cost way to establish the earliest priority date for the invention with fewer formalities. So what it does is you file it, it plants a flag in the sand saying this is what my invention is and what it's going to be. It doesn't actually give you with protection of the granted patent. So it is provisional, but it does give you 12 months to consider your options before deciding to proceed with the patent application. And if you don't proceed after 12 months, it'll automatically become abandoned and it will not be published. You do have the option before that 12 months comes up to roll it over, as people say, so you can refile it, maybe add some more data to it or fix it up. But this, of course, will establish a new priority date. So you've got to be careful if you're doing the rollover that whether you've had any intervening publication of your invention, have you disclosed it to people outside of confidentiality, because that'll come back to bite you. And then within 12 months, you pursue patent protection by filing a standard patent application. And these are the types of applications that are saying, I'm now going to seek protection. And there are different options and strategies, and we will go through those on a later session. But you've got, just briefly, you can do direct filings into territories of interest. So you can go into Australia, US, Japan, pick them all out. Europe is actually a region, and then you have to go through this process to go into the countries. Of course, you could do either of these things in place of a provisional application. But of course, it doesn't give you those advantages I mentioned before. And then there's this international PCT patent application. It's an intermediary application. There's a cooperation treaty. There's 153 contracting states or member states. So you file this application, you designate the countries you want, or all of them, ticking boxes. And that'll go through its own examination procedure, and it gives you an indication of whether the invention is going to be patented, after examination. It also delays the time that you need to decide which territories you need to seek patent protection in. So at the end of its certain period that it goes through its process, you then have, if you designated all the 153 contracting states, I think it's about 2.5 years later, you have to decide, do I want to go into all 153 contracting states or just, 5 or 10? It's a good idea to have an idea of where you might end up going, because you don't want to really do an international if you're only going to want to seek protection in Australia. You go to Australia first and just leave it at that.
2.5 years of standard delivery. That seems pretty long.
Yeah, no, it's 30 or 31 months from the earliest priority date. So if you filed a provisional and then it's 12 months and then another 31 months minus 12. If you filed it in the first instance, it's 30 or 31 months. And I say those two, 30 or 31, because some countries are 30 and some countries are 31. So it's I'm sure they could speed it up, but it's actually quite good to have the delay. So it'll go, you file it, it'll get a couple of reports along the way. You even have opportunities to amend and respond and get it in some order. What you're really hoping if you file a PCT application is to try and get it in order before it gets to that 31 month date. And that stage is called where you have to enter national or regional phase, because most countries used to, although, with changes, if you got a nice, clear, favourable report, it's good. That's quite a good sign. But a lot of countries would be swayed by that. So it gives you, you do it at the one-stop shop, and hopefully it flows into all the other countries. I say hopefully because it doesn't necessarily do that.
Cool.
So patents, it's all about the claims. So these are the statements at the end of your patent specification, which are very, very important. And it is all about the claims, to be honest. So a claim is a statement that defines your invention or inventive concept, and it should define clearly what you're seeking patent protection for. So the words of your claim, and we used to get told as patent attorneys, we're wordsmiths. We make up words, we define words, we interpret words. It's all about the words in your claim. And you use them to distinguish your invention from what is already known, to establish its inventiveness. You set out the essential technical features of your invention or inventive concept. So that's really important, that word essential. So you don't want to, when you're describing your invention, describe it in such detail, because then the more detail you put in is more limiting. So it's sort of like an inverse sort of relationship, if that's correctly the way I put it. So you only want to put in and define what is essential for it to work, but what's needed for that inventive concept. It has to be consistent with and supported by the description that you put in the patent specification. So you can't describe a car and then try and claim an aeroplane. It doesn't quite work. They sort of need to be consistent, the way you use the terminology. If there's confusion about your words, the examiner and everyone else will go to your description and see how you've described it. And sometimes the way you've described it could also limit how it's going to be interpreted in your claims. Should be clear and concise. Sometimes it's clever to use words that you define, but really, the more clear and concise you are, it's easier the life will be. But you don't want to be so clear and concise as to limit yourself as well. And it needs to be written as a single sentence. That's something that's probably worldwide. That's probably the one thing that patents have in common. And I'm just something to mention here, the patent specification may describe numerous embodiments and elements, so you don't have to put all of that in the claims. And these embodiments are, different aspects of the invention. So where you might have, a keyboard that has buttons on it for the alphabet, you might have a keyboard that just has buttons with numerals on it. They're different embodiments, and the elements might be, the buttons, and one's alphabetic and one's numeral. So I've thrown into these slides terms that come up all the time with patents, just to try and give you a sense of what's out there. But sorry, go.
Sorry, I was just thinking and putting it in context, and particularly for a lot of our members too. Like it's easy in my mind to think, oh, if you've invented a physical thing and you could look at it, then you can patent it and describe it as you've outlined here. In something that's a bit more reliant on the description, or it's a interconnected bit of things like an app or whatever like that, or even like a process. I know you talked about the different types of things. Is it possible to patent something that's less physical and more like a process or software?
Mm-hmm. I'm not going to go into software because that's not my area, but you can do processes. So like a manufacturing process, some countries allow business processes, or, a computer that is able to do X, Y, and Z processing. I told you it's not really my area, but there are different things like that. You can also, in my area, I'm a pharmaceutical patent attorney. You have, methods of treatment. So a method of treating a patient for, cancer comprising, giving this drug to them. And sometimes there could be added features where, in combination with another drug and over 3 days, and, to get the effective results. So it's not, it is easy to understand when it's a product or a tangible thing that you've said, but patents do cover other things. When it comes to the IT area, it's being a pharmaceutical patent attorney, it's so beyond me, and I don't admittedly keep up to date with that, although being in-house now, I do need to, because we are, we may venture into those worlds, but of course I will also engage another patent attorney, because a patent attorney is limited to their technical field, really. So that's one thing to know is, I've got a chemistry degree, and then I worked on pharmaceutical patents. So I'm really in that realm. So anything chemical or pharmaceutical, but, if it comes to IT, that will be someone possibly with a physics or IT degree. And then you've got your mechanical engineers, your biotech people, and other things like that. So we are specialised. We know a bit about everything else, but really. We work on our own sort of field.
Yeah. Cool.
So continuous, it's all about the claims. I mentioned before there's two types of claims. So you have an independent claim. So this does not refer to any other claim. So it stands on its own. It must define those features that are essential to the invention or the inventive concept. And you can have more than one independent claim in an application, but they must all relate to that same invention or inventive concept. Otherwise, as I mentioned before, you won't have lack of unity. And then you have these dependent claims. So these reference one or more of the previous claims. They further define essential features or additional features considered desirable or optional to the invention. They're also referred to as fallback positions. So if your independent claim gets knocked out, claim 1 gets knocked out, you'll go to claim 2. So claim 2 is all of claim 1 plus what you said about claim 2. And then you might have claim 3, which refers back to claim 1 and 2, or just 1. So that'll be really, when you read it, it's claim 3, 1 plus 2 plus 3, or 1 plus 3. So this is how they work. It can get very confusing, but you try and put in, those important fallback positions. So you try and minimize the essential features you put into your independent claim, but you might push the boundaries to argue is a patentable invention. But you always have these fallback positions in case you get knocked out. So a lot of provisional applications, you will look at the first claim. They don't necessarily have to have claims in them, but people put them in now. And you go, yes, that's not going to get through. And it's because you're going to push the boundaries. So you don't try and go for the invention first off. You try and give yourself some room to move. A standard patent, you can have as many claims as you like. And back in the day, there were hundreds and hundreds included, but then a lot of jurisdictions started to impose additional fees for after a certain number of claims. So in Australia, more than 20 claims at acceptance. So if your case gets all the way to acceptance and you've got more than 20 claims, you'll incur additional fees in addition to the acceptance fee. And if I recall correctly, it's like $100 for each additional claim. So if you've got 25 claims, there's an extra $500 like that. And there's a lot of countries that have these. They're not necessarily at acceptance. They could be at filing. They could be when you request exam fees. There are fees payable all the way along the process. So, overview of the patent process. So, once you've filed your application, they take place before the relevant patent office. So we've got IP Australia for Australia, USPTO in the US, European Patent Office, and there are European patent offices in many of the European jurisdictions. Now, the European here is different to European Union. So European Patent Office has certain countries in it, and it depends which where you engage or associate overseas to where that, whether it be before the UK Patent Office or a Danish Patent Office. But they consider themselves European for that purpose. So, as I mentioned earlier on, the process is not the same in each country or region, but generally these are the things that may happen. You file. So you file with formal documentation. Some of the documentation may need to be signed by the applicant or inventors. I call them old school countries because many other countries it's all electronic filing now and quite simplified. It will then go through either a pre-examination or formalities step, and that's just compliance for legal requirements. Have you lodged all your documentation properly? Some patent offices might do a preliminary search and send you a report, just say, this is what's going to come up. Then you go through a substantive examination stage, and some countries are automatic, but most countries you have to formally request. And there's different ways you can request examination. So I thought they're normal, modified, PPH, and accelerated. I might go through those when we go through the strategy session in a bit more detail. And then we call this, once it's examined and you get your report, we go through a prosecution stage. So that's when you're going backwards and forwards with the examiner, trying to overcome your objections in the adverse report. I mean, if you're lucky, it could just jump this step and go, be examined and go straight to acceptance. very, very rare. But, does happen. I think I had a few in my time. In Australia, we call it acceptance. In the US, they call it allowance. So it does, some of this terminology I've tried to show you, put the same sort of terminology together because sometimes it comes up in different contexts and then you're not quite sure which is which. And then there's an opposition. In some countries, it's pre. So once it's accepted, it gets published and it's like, hey, this case has been accepted. Third parties could see that and go, oh, I don't think it should have been. I know about something that would block it. And then they go through an opposition and then they oppose it. And sometimes that's post-grant. So in Australia, it's pre-grant. In Europe, it's post-grant. And then you go through this opposition. It's like for want of a better word, it's like a mini court case. So they lodge their evidence, you lodge your evidence, they lodge their evidence again. Then it goes to a hearing, you argue it out, and then you get a decision from the office. So if it's pre-grant, if you overcome that successfully, you'll get to grant. If it's been granted that it's post-grant, your grant gets revoked. I've written there re-examination. This can happen after grant, particularly in Australia. Probably other jurisdictions would be similar. But third parties can ask for re-examination, and they can in some countries could do it anonymously. So they do it through their attorney, where they don't have to be identified, but their attorney files it. So usually when we do that, we used to get some other attorney if you represented a huge client, so they wouldn't guess who it was coming from. And they can bring up, things that, raise the issues that may not have been addressed during examination. So just because you actually get a granted patent, it doesn't necessarily guarantee that it's there forever and that it's valid. It's just gone through that process and found, yep, you got it over the line. As much as, I'm the examiner, as much as I know, I think it's worth, giving you a patent. But of course, they can't know everything. And I've just done a note there that litigation, so when you infringe a patent or if you want, counteract that with revocation to attack the validity of the patent, that all takes place, in Australia, before the federal court. Okay, so we keep going. So I just wanted to go a bit more into examination and prosecution. So standard patent applications are examined, provisional applications are not examined. So with a standard patent application, when it's examined, the claims are searched and assessed for patentability. There are other things that are looked at, but that's essentially the main primary purpose of examination. There's usually a limited time period for responding to an adverse report. These periods of time are not the same from country to country. And it's also very important to note, is it a response deadline? Or a deadline that you must place the application in order for acceptance or in some shape or form. And the difference there is, if it's a response deadline, you could probably file it the day before the deadline and it's in. You've made the deadline. If it's a deadline in, you must place the application in order for acceptance, and that's with Australia. You've got to give the examiner lead time to file for you to file the response and for them to then consider it. And, if they've got to come back with another objection, you've got to give them time to issue that report and give yourself some time to respond to it. So there's differences when you get an adverse report. You need to read exactly what's required there. Most countries, if a response does not address the objections, a further adverse report will issue. And sometimes it doesn't have the same time period as the first report. It might get limited. It also might limit you in what you can do. But usually you'll go through at least one round of reports. In Australia, I think if you get to the third or fourth report, you're sort of having a bit of trouble. The examiner might suggest to go down, set it down for hearing, which I've mentioned there. So if there's unresolved objections or a disputed outcome, the examiner might go, let's go to a hearing and sort this out because we're just getting nowhere. And I've just mentioned there prior art. This comes up during searches and examinations. So that this is what's cited against your application. Say, look, you wanted this invention. It's not new. Here's a publication which essentially shows your invention. So it's any information available for consideration when determining whether an invention is patentable. So it's patents, non-patent literature, so articles, publications, and prior use. And it may extend to unrelated areas because when they consider your claims, they take the broadest reasonable interpretation. And, so it's how you've defined it. So that's why sometimes there needs to be amendments. Sometimes that's why you see, I've got a pharmaceutical, but it's citing something in a different art. And then you might go, oh, yeah, it's my term. Yeah, it does take in too much, so I need to sort of fix it so it's limited to my field and to exclude it out. And then we've got responding to objections. So I was asked, what can you do in response to objection? Do you just have to agree with the examiner? Well, the answer is no. You can always ring the examiner or get your attorney to ring the examiner and have a discussion about it. But your options are arguments or submissions. So if you think the objections are reasonable, you can respond setting out reasons why the objection is not warranted to convince the examiner to withdraw the objection. A simple assertion will not be enough. So if you just go, no, I disagree, definitely won't get you there. The other option is and these are and or, so you're not limited to one or the other. You can propose amendments. So this is to address deficiencies or to distinguish the invention from cited prior art. And then you can provide additional examples of the invention sometimes this is needed to exemplify that your invention works. If the examiner's having trouble understanding it, you might give it logic, set out an example of what you did on the lab bench or something like that to show how it worked. And sometimes, and in some jurisdictions, these are very useful, but you don't do it as a general step, but sometimes it does come into play. You ask an expert to do a declaration. So this is an independent person who has a better understanding of the whole technology of your invention, and they can do a declaration saying, no, I think you've misunderstood what's known in the art. I'm an expert and I wouldn't have put these, A plus B plus C equals D. I wouldn't have guessed that. So that's the sort of thing that also helps in some instances. And I mentioned there about proposed amendments, and I thought I'd make a special point about this. So amendments, once you file your application, there are limited options to change or amend your patent specification. So with the provisional application, if you were, and we very rarely did amendments to provisional specifications, but any amendment that increases the scope of what you've tried to cover will not be allowed. If you've already filed a provisional application and you feel like you need to add matter because you missed something or you've just discovered something special about it, you need to consider filing a further provisional application, and you do that as soon as possible to secure that priority date. Now, you can either do it as a replacement of the original one. The original one should be normally allowed to lapse, and then you file the new one. So there's not two at once if you're going to do that. But what people do sometimes is they file their initial one, do some work and get some further detail, file a second one, and then 12 months from the first application, put them both together and go into that next stage of filing that standard patent application. So with the standard patent application, different considerations apply to, in most jurisdictions, to whether you file an amendment before acceptance or after acceptance or grant. So before acceptance, you pretty much can do anything within your document as long as it's all within that document. So it has to fall within that scope of that document. Once it's accepted, in Australia, the amendment must fall within the scope of the claims as accepted. So that's more limiting. So really, you've got to be very careful. If you've done what you needed to do, once it's accepted, you then got to go fall within the scope of the claims, and they're usually more limiting than what was in the description. Oh, got to the end. Any question? I'm going to stop sharing so I can see you. How was that? Whirlwind of patent information.
Whirlwind of information. Yeah, look, I think, from my side, just having awareness over the different terminologies. I've not touched on them for a long time, so it's great to have that refresher of the different types and what those processes might look like. And I think it'd be helpful for many in the community to just be mindful of what it looks like in terms of going through this process and what to expect and so on. Yeah.
Yeah, I think I'm hoping it'll be a good reference material. The more discussion strategy, although I can only over give an overview of strategy because it all does depend on what people are doing. But I do want your community to know that, well, I am in-house, and if they do want to reach out with a quick question or something, they are more than welcome to and ask me a question because I'm now unbiased. I don't have any need to acquire clients like I did when I was in the profession. So, and yeah, I'm willing to help. So,
That's right.
I have a question, Rosie, based on so you mentioned that if you're working on developing a product, then, that IP is owned essentially by the company, But then what happens in the instances where companies actually collaborate with universities to do this, or they have university staff kind of on their roles? Who owns the IP?
Good question, Roy. And we will talk about that more in another session, but I'll just ask that. So usually, and one thing that companies do need to be very careful of is that usually you'll have an agreement with that university, and hopefully, if you've negotiated well, you've got the terms say that I'll engage your researchers to do this work, but any IP created comes back to me. Some universities push back on that. Some, in material transfer agreements, they push back on it. Got to be very careful to read the fine print. That's one clause that I go to every time I'm shown a document or an agreement. It's like, where do those IP rights go? Because it does start with the inventor, and if you didn't even have it covered, it didn't say, it was silent, it would go to the university. So even though you've paid for it, that's how it happens. Yeah, so those intertwined collaborative arrangements, got to be very careful how it all goes and all falls out. And then, of course, there could be joint ownership. So that could also happen as well. That's a meeting ground. If maybe the university and you, usually the university will want the rights to research and publish. And you just got to make sure they don't publish before you file your patent rights. Stephen, I was going to ask, have you had interactions with patents?
More trademarks and copyright sort of information in the past. Not so much in the manufacturing sort of space. My interest was really about, and a little bit of outrage, I guess, is overseas companies patenting inventions that are made elsewhere because they've got more funds, and how that is possible, and how to protect yourself against. Particularly as a startup, we are not in a cash position to be able to go patent everything that we do if it was patentable. But how do you, protect yourself against somebody who is cashed up and comes along and just starts patenting things that other people have maybe invented but haven't been able to go down that process because of the financial constraints?
I can say I've already started my strategy session presentation, but I do go into that, some of the
Right.
Because it is hard. And do you patent everything? What are you trying to patent? It's I try and bring up what we need to think about.
Yeah.
How you might go about it. Because like you say, I work for a startup as well. Patents can be very costly. And you just got to use that money wisely as much as possible.
In the physical device world, and sort of like, if you're agriculture or whatever, you're working in a geographical sort of area for a device. But when you start crossing over into software, particularly software as a service, your day one market is global. So do you start with Australia because you happen to be based in Australia, or then you've got a second customer and they're in the EU and they're huge, and then suddenly you've got to run to the EU and patent there, and then your third customer's in the US. It's sort of like that strategic rollout, and then how do you protect yourself and balance particularly, cash at that early stage between, do I put it in the product or do I put it in making sure that a product can't be taken away from me, or I can't be excluded out of the market because someone's got deeper pockets?
Yeah, that would be hard because it's a service. But I could say from my experience, even when I first started, pharmaceutical companies it was great. You'd have this portfolio that nearly went to every countries I hadn't even heard of.
Mm-hmm.
Even they've right. It costs a lot of money. And so you just have to be as best as you can strategically decide which countries are going to need that protection. And then how enforceable, how good are that patent laws for you to enforce it? Because, some countries, if you've got no presence, I'm going to say India, I've been to India 8 times. I had people there on the ground. If I needed them to do something, they're there. But if you don't have a presence there, one, do you even know it's being infringed? And 2, if you had to go to court, do you even know the system, where to go, what to do? So there are a lot of things to think about.
Yeah, and that's the concern. Even if you go down the path and you fund it and you've got it all, then somebody challenges it with deeper pockets, the likelihood of it actually standing up. And then the other area is interest, particularly pharmaceutical. I guess I hear about a lot more is when a patent's close to expire, the ability to make a change and then repatent something that's similar but not quite the same, to extend the market, blocking the market, I guess.
I don't know how intentional that is, because I would think if I was a pharmaceutical company, if I had a modification that improved my drug, I would bring it out. You wouldn't wait. You just bring it out. But sometimes those modifications just happen to happen. They just happen, and then they do that. But it has to be a significant, enough of a modification on this one. So, but there is, that I think the term is evergreening, and so they do, they file a molecule, and then, but this is how it works. They on the lab bench, I've got this molecule works. Oh, then I have to do the formulation, and then that could be a few years later, or 5 years later. It's like, even with products that sometimes happen, and then it's like, oh, hang on, I could do it in a slow release dose, works even better because now I've got more data, and it's just an evolution. I would hate to be sitting there going, I'm not going to release that. Let's just hold on to that for a couple of years, and then need to do that sort of silly strategic thing. You'd hope they'd want to just get it out there to help the patients. Yeah.
So,
all right.
Perfect. Well, thank you. Look, we'll make this recording available in the community or the website as well, and notify members in the next couple of days, so they can go watch it. And thank you, Stephen and Saul, for attending live. Saul had to drop off, but look, it's been a great reason. Looking forward to the next one.
Great. It's on branding. Trademarks.
Nice.
I think I'll be sitting back in my ex-colleague who's now got her own firm. She's doing it. She's great.
Excellent. Look forward to that one. Thank you.
All right. Thank you.
Day.
Thanks, guys. Have a good one. Cheers.